closer, I guess. Okay, you have on the consent calendar, you have the approval of the minutes for the special meeting held March 30th. Also, the payment for bills for the period of May. The staff report contains a invoice for GlowTrans. We also have an invoice for, let's see, first remembering here, the U.S. Postal Service, Palmdale Water District, and Todd Groundwater, along with Antelope East Kern Water Agency. Be happy to answer any questions that you may have with regards to the consent calendar.
Okay, for the consent calendar, I'm going to take the consent calendar item A, first payment of the bills. Is there a motion to approve payment of the bills? Moved by Dennis.
Second.
Second by Kathy. Any discussion? Seeing no discussion, all in favor of the motion to approve payment of the bills, say aye.
Aye.
All opposed, motion carried unanimously. Now we're on approval of the minutes of the special meeting for March 30th, 2017. Is there a motion to approve the minutes of March 30th, 2017? Motion made by Dennis, second by John. Discussion? Seeing no discussion, all in favor of consent item B, approval of minutes, say aye. Aye. All opposed, motion carried unanimously. Next item is the finance report. Wayne or Matt?
Yeah, I could provide a little bit with regards to that. The cash and funds available that we have at Citizens Bank, just the bank balance at the ending of April 30th, 2017 was $9,652.75. The total expenses, total current expenses was the $37,000. $341, which we just previously approved. So the bank balance will at the end of the month, once with those bills being paid, would be $9,652.75.
And we're going to be discussing that later in the meeting, is that?
Yes.
correct? Any action necessary on the finance report? No. Move along to action items. Agenda item 7, action item A, continued discussion from April 26, 2017 meeting on appointment of higher administrative staff and responsibilities and duties. I understand that the advisory committee had a meeting and the recommendation if Dennis wants to come forward and discuss that with us. Is there a motion to receive and file the finance report? So motion made by John, second by Dennis. Any discussion? Seeing no discussion, all in favor of the motion say aye.
Aye.
All opposed, motion's carried unanimously. Now, Dennis. Thank you.
Good morning. Dennis Lamro with the advisory committee, elected to be the spokesman, like me. On this item, we discussed, or the advisory committee discussed this and believes, regardless of the staffing changes, that it would be best to move towards an independent administrator for the water master, where none of the parties are involved in the administration of the water district.
Was there any discussion on the budget for that or what that would cost?
Actually, the proposed budget has money in it that would go to either the agencies that have helped or are helping now. That could be used for a contract administrator.
And any discussion how when you say independent administrator, what that would look like? Is that a separate water master staff with secretarial help, administration, all of that, or what was the discussion?
I think the feeling in the committee was that it would be best to completely contract that out, rather than to use any agency. I mean, if that administrator felt that it was best to use maybe one agency's financial software, that could probably be worked out. But the control of that will be by this contracted administrator.
And would that be, and I'm just trying to understand the discussion, would that be a full-time administrator, part-time administrator?
I think the idea is it would be a contracted duty, maybe with somebody who does this, so it wouldn't be necessarily full-time, it would be the time that's needed to administer this judgment.
And would that include all the billing and billing software and administration for billing and all of those things?
Again, that would depend on, what the policy decision of the board is. Like I said, if that administrator thought it was best for one of the agencies up here to use their financial software to help with that process, that could probably be worked out.
Okay. Thank you. Appreciate it. Any further discussion? Further discussion from anyone?
Right, my only concern is, I think in the budget that Dennis is referring to, we have $38,000. So that's not a lot of money to either hire part-time or full-time staff. So we need to discuss, if we go that route, we need to discuss how we fund that position. And also, the other concern that I have, I'm assuming that everyone wants to hire somebody locally, because it would be a lot cheaper than to have somebody travel here. So is there somebody locally that can provide such a service? I don't know if it's in the packet, but I saw, at least at the public law suppliers meeting, I saw a description of the duties of this administrator. I don't know if we have it here or not. I thought it was quite a bit of responsibility, so that needs also to be fleshed out.
And just for everybody there, I wasn't at the last meeting, but Phyllis, I know you were at the last meeting. And welcome aboard, by the way.
Thank you very much.
So, do you want to weigh in on this discussion at all, or?
I always have an opinion, so thank you for asking. We have benefited greatly, I think, by the institutional knowledge of the current staff members that have assisted us. We're still trying to get our feet under us and coming up to speed. The list is short for the things that we need to know, but the details are quite significant. And as a result of that, we have continually relied heavily on staff, and I think that it would benefit us. We attended the advisory committee meeting. We recognize their concerns with having independent administrative staff, and we appreciate that concern. From my perspective only, it would be advantageous to at least keep the current situation in place through 2018. I just ask that as a consideration. We can work with you in any way that you would like to. There's been some options on the table for perhaps continuing to use agency software. I think there's some advantages to taking advantage of the resources of local agencies. In particular, there's a requirement, as you know, for a financial audit at the end of every year, and that is something that I think public agencies are used to and can manage very easily. It was also suggested that perhaps that could be a subcontract to Todd Groundwater. That's acceptable to us, of course, if that is the Watermaster and the community's desire. But we want to if we're going to take responsibility for that role and it's financial, there's banking associated with it, and as a result of that, we would want to, we would just simply ask that we get enough time to get our feet under us with respect to what's required, recognizing that such a subcontracting position would be in our charge and our responsibility.
Thank you. Any further discussion?
Well, I at one time probably would agree with the subcommittee, but at this stage of development of this board, I would be, I'm very pleased with the work that's being turned out. I don't see how we can do it any more economically if we have to take more time and energy to establish a new staff. So I'm very pleased with the status quo, and in consideration of what our engineer's request is, I think I would like to go back and agree with her.
Thank you, John. Any further discussion?
Just for clarification, John, are you open to the idea of revisiting this, say, early 2018, to see if at that time maybe it is more appropriate to hire an independent?
Absolutely, I'm always open to revisiting it. I just think at this time, it's like changing horses in the middle of the stream. It's not the time.
I'm for that idea. I'm for the idea of continuing the status quo until 6, 7 months down the road, and see where we are, how things are, how our financial situation is, and then reevaluate.
Very good. I'm good with that. Dennis? Yeah.
So to be clear, that means that Palmdale Water District, in the absence of Matt going to AVEK, we will be having Peter Thompson do that.
I don't think that has been discussed. And
So you're just saying that then Matt and Dwayne will continue to do it?
I think we certainly can discuss that here.
Right.
So just so everyone knows,
That's
and
what I'm saying.
Matt has just joined the AVEK staff as assistant general manager, so congratulations, Matt. But that does bring us up to another topic of discussion. Originally, when we formed the administration for our water master board, it was a combination of AVEK staff and Palmdale. Palmdale has continued to do the billing. Matt and Dwayne worked as co-administrators, so we certainly can discuss that change because it has just happened, and probably get some input from Dennis as to his thoughts and have some discussion about that. Personally, I think it's worked very well with Palmdale and AVEK doing the co-administration. Dwayne and Matt have done an excellent job, but because Matt has now moved to AVEK, it's certainly time for us to have that discussion.
Well, that's why I was just opening it up to be transparent in my understanding of us in our public water supplier meeting. All the financial records and the software that we're currently using is housed and is at Palmdale. So a lot of the functions that Matt is leaving, we have Peter Thompson who is going to be taking those on. He attended our meeting. He has said that he would do that, as well as Dennis is fine with that. And he also went to the advisory committee. I feel very confident that, I want to be transparent so you guys understand there is a change in that.
And maybe, Dennis, can you come up and say hi to us?
And maybe tell a little bit about Peter Thompson, so.
Is he a new hire? Or
Yeah, see, that's what I'm saying.
How have you been on staff?
Well, yeah, and introduce Peter Thompson.
He was born and raised up on the Water District.
There's been a couple of those. I have to take off my advisory committee cap, because that position, recommended we move forward, or that committee's position recommended we move forward with the change. Hopefully we can revisit that before the end of this year. As far as dividing if we continue on the current course, As Director McLaren said, the finances are being handled by Palmdale Water District staff. And I believe the billing has been handled by staff.
Yeah, that's correct. There's a couple staff people, other than myself and Peter, that handled the finances and billing aspect.
You know, so I think as long as we have that balance, you know, that should probably be helpful to the board, and we can involve Peter Thompson also. He's with our water and energy resources group, and is going to be stepping more into this, and the state water contractors, and you know, maybe the public water suppliers group that gives direction to that seat. So he's very capable in that role. As far as putting together agendas and that kind of thing, we can certainly give input to the gentleman over there.
So I'll give a recommendation. Why don't we have Dwayne, Matt, Dennis confer on this before the next meeting and come back with a recommendation as to how we should proceed. I just want to make sure everybody's on the same page and in agreement, and I didn't know what your wishes were, and since you're the GM of Palmdale, you should weigh in on it, I would imagine. Okay, with that,
That's fine. I thought it was clear to me that public water suppliers would like Palmdale Water District, with your permission, of course, to continue doing that role. And if Palmdale Water District is okay with that role, I think that's the way to go.
yeah, and I think just looking down the table, that's probably the consensus. I just don't want to figure it all out here. I'd like Dennis, Dwayne, Matt to work on coming back to us with a recommendation exactly how to do that. Would that be okay?
Yes.
Everybody in agreement? Okay. And thank you.
Sounds good.
Any comments from the public?
Yeah, okay, let me clarify this. So you're gonna hold off until you're gonna go against the advisory committee's recommendation, which was unanimous, is 100%. You're going against them, and you're gonna hold this off until 2018 to revisit it. Am I correct?
John, if you want to come on up to the mic so people on the phone can hear you, that might be better.
John Ukkestad. Let's clarify, I'd like to have this clarified. You're going to go ahead and you're going to hold this off until 2018. You're going against the advisory, 100% of the advisory committee on their recommendation to go with an outside subcontractor. Am I clear?
I don't think that's, I think what she's saying for the engineer, that she's thinking that 2018 would be the time that she's looking at right now, that she would get adjusted to what we're doing. With all the other stuff going on, keeping as it is, but I don't think anyone here has said that we wouldn't be willing to retouch on it or bring it up before that amount of time. Because she may change too. She might get in there and everything is going well, and then she could tell us that she feels now's a good time to bring the idea.
Wouldn't that be revisiting, Kathy?
Yeah.
Yeah, that's what I said.
Yeah, so I don't think that anyone here said that we wouldn't revisit it and have to wait until
2018?
18.
Excuse me.
John, the advisory committee is an advisory committee. So we're taking their advice and we're taking the action we're taking. I think there's some other discussion. We're taking their advice.
You're hearing you're listening to what they have to say and making the decision
Correct.
of what you want to do.
Exactly what an advisory committee does.
Okay, and that's exactly what you're doing.
Yes,
Okay.
thank you. Gary?
Good morning.
Just say your,
Gary Van Dale, High Desert Dairy landowner,
thank you.
and I was not at that advisory meeting. I was there for the first part of it and had to go when the vote was cast on the staff, and I'm okay with the staff and everybody that's behind me is okay with the staff as president.
Thank you. Any further discussion? Seeing no further discussion, we'll move on to item 7B. And that's continued discussion from April 26, 2017 meeting on proposed calendar year 2017 administrative budget and administrative assessment.
May I, Mr. Chair? Did we need a motion for your recommendation to have Dwayne, Matt, and Dennis talk among themselves and come back to this board in a month, or how do we conclude that?
I'm fine with the motion. I think consensus is fine also.
Okay.
If you,
No, whatever you guys think, do we need a motion to do that, or? We need an action item.
well, we'll bring it back as an action item on the next agenda.
Okay.
I mean,
You can vote to table it.
well, there's
It's a
no,
discussion.
there's no motion on the table,
Yeah,
so it's a
'cause
discussion item on the
continue
agenda.
discussion.
So we'll just put it back on the agenda once we have some more work done.
Okay.
And we can direct our administrative staff to do the work.
All right.
Okay. Everybody good with that? Now we're on item B. Dwayne or Matt?
Okay, I'll start this off, and Matt can jump in as appropriate. We have included in the board packet was a sample administrative budget for 2017. It was included to begin the discussion of the budget for 2017, as noted in the finance report. It's important that we move forward in the assessment process in order to generate some revenue for the account, to be able to pay the watermaster engineer as she continues her work for completion of the first annual report. There's a couple of things that have come up as far as discussion items, and we need some clarification with regards to those. One is the variable amount for that we're assessing in 2017 for the 2016 year. The assessment for 2016 was $1 per acre foot. So there's a question is the variable rate for 2016, should that be $1 an acre foot or at the higher level, since it was, since the actual water was taken in 2016, I think it should apply to the $1 per acre foot, not the higher level as far as variable assessments. That way you keep your years completely accurate and the same as far as the assessments go. So that's one issue that which affects your revenue side of the Watermaster Board. One decision that needs to be made. And the second decision on the revenue side has to do as to whether the non-overlying production rights for Exhibit 3 and Exhibit 4 apply in 2017. And reading the judgment and looking at that particular line item that talks about assessing these overlying production rights, it talks about what your production rate is minus your minus the amount that you're assessed for replacement water. And since there is no replacement water requirement in the first 2 years, 2017 being the second year, we're not sure that that particular provision applies. And our estimate, and this is just an estimate, it's not, gives you an order of magnitude, is for about $48,000 in that particular item. So it's very important to make that legal determination as to whether that would apply or not. because there is no replacement water assessment for 2017. And my thinking is that as I read that provision is in the first 2 years that these two variable amounts didn't apply because there was unlimited pumping rights during that period and would occur in the third year. Now, I may be wrong about that, but that's an important distinction because that would really have a lot to do with whether that's done. So there's going to be people who are overproducing their rights during the unlimited portion that would get an assessment. And I'm not sure that they understood that they would be getting additional assessment for that period. So, and I'd be open to any particular legal interpretation that would clarify that situation for us, because that's a kind of a sticking point, so to speak, on the revenue side to make the revenue accurate for 2016. We've also included in the administrative budget estimates from 2018, 2019, just to give an idea of what the costs are, because as you know, the major cost component of the budget is the Watermaster engineer contract, which is higher in 2017 than it is in 2018 or 19 once it gets that through. So, so we have those two items that we need to have some resolution on for the revenue side of the budget to be able to give you some accurate numbers as to what you can anticipate for the revenue portion of it. We have, and then we have well, why don't we just stop there? Maybe we'll have a discussion on the revenue side of it, and then we can talk about the expense side. And it's, we need to have an accurate description of the revenue in order to be able to have to get an accurate assessment, because if the revenue changes and the expenses change, then that's how you come up with what the assessment's going to be. So.
Dwayne, are we sending the supplemental bills for 2016?
It would be, in other words, there is a variable, what we call a fixed and a variable portion of the assessment bill. The variable portion needs to be sent for 2016, and we need to do the assessment for the fixed portion of 2017. And the reason why the assessment or the variable assessment is late is because you need to know exactly what everybody's pumped. They need to report it, and for the water master to be able to identify and develop those numbers before you can do that assessment, and that doesn't occur till after the end of the actual year is done. So there's likely going to be a 3 or 4 month change. So at the end of 2016, everybody gets their numbers into to the water master engineer. The water master engineer will assess all those numbers, then come up with exactly what that variable portion is, which will ultimately be assessed in 2017.
Now, this data has been collected, correct?
It has been collected now, yes. So we don't have the exact numbers yet. We have the data. She's working on that, but we need to have this clarification, because I know there's a lot of people that believe that if you overproduced in 2016, that you have an assessment that's that you need to pay for that overproduction. And the way I read the judgment, you don't. And but I need to have that verified.
So, and then, for the same reason, we're sending this, what you call variable assessment for 2016, we would do for 2017.
Correct. So it'll always be that way, because it's just you're unable to do it. So you're always going to be 3, 4, 6 months in the rears on the variable assessment.
Right.
Ron Smith. Welcome.
was sick for a few days here. But Ron Smith, Rosemont Community Services District. I'm part of the public water suppliers, and we've had a very protracted discussion with the attorneys and everybody else, and have a different definition of what Dwayne is, but I'll tell you where the catch is right here. He's correct as saying that the production right under 3.5.32 says the amount of native shade yield you can produce each year free of replacement water. And during these first 2 years of the ramp down period, you can produce as much without having to pay replacement water. The only glitch is, within 9.1, the administrative section, it says each acre foot of the party's production right, and then it defines it even further, as described in paragraph 5.1. So for Rosemont, that means that my description is 404 acre feet. Then as you come down towards the end, it says, during the ramp down, each acre foot of a party's production in excess of 1 through 3. So therefore, anything that I pumped above and beyond what was described in 5.1 is also assessed. And I think most of the attorneys, that's what we had this discussion publicly before, and they were all agreeing with that assessment. You can talk to some of them, and we've had a lot of letters going back and forth. And so, in other words, this paragraph, it's every acre foot that you pumped. Everything is in there. Every category is in there. But I think that the glitch was, when you look at the straight definition of production rights, it is no replenishment. But section 9.1 specifies it and tightens it up even further. So that's my position.
Thank you. Well, we have a large group of attorneys in the crowd. I need you guys to weigh in.
I'm afraid I don't have much earth-shattering to add, but I did want to respond that apparently there have been many attorneys working on this, exchanging communications. I haven't seen any of them, and I'm not prepared now to express an opinion one way or the other about what water should be assessed in 2017. I do want to quickly talk about the other issue, the pumping in excess of folks' production rights in 2016. What's the right dollar value to put on it? I think that judgment does use the words about establishing an assessment, that one assessment that applies to the year. And I'm uncomfortable with the idea that in 2016, pumpers know that they're going to pay $1 an acre foot on their right, but that they wouldn't know what they're going to pay for any overproduction they might have. And so I think it's consistent with the judgment. I also think it's just at a policy level, folks know when they pump what costs they're going to incur. And so I do think there'll have to be other adjustments in the budget. You're going to have to pull in enough money to fund it. It's almost a detail. It depends on how much you put on each number. But I think the right way to do it, if you pump it in 2016, you pay the 2016 level assessment.
Thank you.
Thank you. Further discussion? Oh, you did. For everybody on the phone, just you need to state your name and who you represent.
Sorry, Stan Powell, representing the state of Los Angeles.
Thanks, Nick. Anyone else want to weigh in on that? Thank you, Warren. Warren Welland from the County of Los Angeles.
Thanks. Good morning. I think Ron is correct with respect to the administrative assessment. It's set forth in section 9.1 of the judgment. And I think Ron correctly pointed out maybe a minor disconnect is probably too strong of a word. So I do think he's correct. I do think the administrative assessment is assessed against all pumping during the ramp down period. And then also to address Council's statement a second ago, Ron alluded to conversations among attorneys, and it was just the public water supplier.
I just want that to be clear.
Yeah, no, absolutely, and I appreciate that. And you know, one of the purposes for having this meeting, you know, is for everyone to talk about this and be transparent and try to get to the bottom of what we're supposed to do on behalf of the court who we're essentially working for. So anyway, thank you.
Thank you, Warren.
I'll follow whatever the board direction is, and I would feel more comfortable if we had some written determination that, set forth exactly what these procedures are. There's an item further in the agenda that's asking for a presentation on these matters and others that would really help to the administration of these assessments so that we can do it consistent with everybody's interpretation of what the judgment is. In this case, Ron looked at a different section. I looked at the assessment section and reviewed that, and so, there's different interpretations based on what you're reading in one section versus the other. And for the board to have a policy that has been vetted and the majority of people are in agreement on would make this much easier to administer moving forward. So be happy to do whatever direction the board wants to give, but I think it's important that you have a written documentation that's been vetted by the majority of the attorneys that are involved, so that we are consistent on that particular fact, and that we don't go through an audit of that type of thing and then find out that, hey, we made a mistake and have to refund money and other types of things. So we want to make sure that we get this one right, so that we're there. So.
Recommendation on the procedure.
On this, your production rights and your overpumping, we're saying we're gonna charge the same amount, the overpumping is not gonna be charged the replacement water fee?
Assuming, if I'm interpreting what we're talking about correctly here, is that there would be no replacement water assessment, but they'd have to pay the administrative assessment for all water pumping.
And when is everybody's opinion that the replacement water fee would start? At the end of the
Well, it would start, no, it would start, that's my whole point, that you have a ramp down and you have a specific allocation that you need to meet. So if you go in the first year of the ramp down and you're 80%, if you pump over your 80%, then you have to pay your replacement water for that 80%.
And the 80% year starts in 18? Is that right? Is that
correct?
18. And how are we going to determine the replacement water fee?
Well, that's a discussion for another day.
As long as it takes us to decide stuff, we probably ought to get started on that. Because if you're going to have to go out and buy water and transfer it and move it over here and all that, that's going to be expensive.
There certainly will have to be a process associated with that. The board will have to determine how much assessment water that they have, and they'll need to seek additional water supplies and what people are willing to provide to make that occur.
I would imagine part of the rules and regulations would have to be the assessment water.
Right.
Yeah, I think we're going to start soon.
Phyllis, you want to weigh in on that?
Thank you.
So, we need to come up with a plan how to resolve the issue about the assessment, because we have to get the assessments out, right?
Correct. We need to get a budget adopted so that we can do the appropriate assessment.
Right.
What I was going to say, the way we did the first assessment was with a resolution, correct?
I believe so.
I think it was a resolution. Why don't we do the same exact thing? We do a resolution for the variable assessment for 2016 and the fixed assessment for 2017.
I think as we're in disagreement, or not in disagreement, there seems to be a different interpretation of what the judgment's saying. We want to get it right, so we need to have a process to make sure we get it right, so we don't put it out and then somebody objects to it, or so. I think if we can build consensus, we got several attorneys in our group right now. I know that the public water suppliers, from what Warren said, has discussed this issue. I don't know if the other attorneys have. Lee, do you, has anybody else weighed in on this, do you know?
The Antelope Valley East Kern Water Agency. I don't think I want to weigh in on this particular issue at this point, but I would like to remind you of one other aspect which I think is important, and that is there are some parties that are pumping that don't have an allocation. For example, Phelan does not have an allocation. Attorney Brumfield's clients don't have an allocation. Presumably they're pumping as well. And one comment that's been made to me is that it would be important for the board to set rates as soon as reasonably possible. Those people are going to be presented with a bill, presumably at some point in time, for the amount of water they've been pumping that they have no allocation for. And rather than waiting 2 or 3 years before a bill is, or rates are established and bills are presented, it would be good to put them on notice as early as possible as to what their obligations are going to be.
And that's the cost of the replacement water, is that correct?
So, and the assessment.
And the assessment, yeah. So, because they haven't been assessed anything at this point.
Have not been allocated or assessed anything, is my understanding.
Good point, thank you.
Keith Lemieux, Little Rock Creek et al. I did that like I was in court for a second. So at least I didn't spell my name like I was.
Just address your honor and we'll be.
Look, on this topic of what pumping goes into the administrative fee, I don't think this is an ambiguous issue, and I don't think there's any disagreement among the attorneys that have looked at it that I know of. There isn't a legal issue here, as far as I can tell. What I recall, I don't have the language in front of me, but what I recall about it when we were negotiating was originally there was a loophole there on the pumping. Originally it was just the original pumping. As I recall, the last loophole that was closed was, as you know, the public water suppliers can pump a portion of the Federal Reserve right. For a while, that administrative fee section was quiet as to whether or not even that was included, and eventually it said if the public water supplier pumps the Federal Reserve right, then that counts towards the administrative fee. So the intent was all pumping, is what I'm trying to say. And it is actually spelled out in there. I don't think it's really subject to a different interpretation. I'd like it, you know, I'd like to say that there was some loophole that you know, somebody could exploit maybe to get out of it, but there isn't. It's meant to be total pumping, and that's the way it was negotiated.
Do you also represent Roseman or who?
No, that's
Greg,
Doug Everett.
Doug Everett is our attorney, he's probably online.
Okay, great.
But again,
And he has the same assessment.
yeah, we've all looked at it on our side, and I'm not aware of anybody who's looked at it and had a different opinion on this.
So until we get an attorney, obviously we can't give assignments to attorneys. Is there anybody who wants to volunteer just to write a short memo on the interpretation that we can put out to everybody and get consensus before our next meeting so we can go forward with our assessments? That would be.
I think we've actually written something. Didn't I write something about this to you guys? I think we've written, the public water suppliers have written something internally on this.
Okay.
And rather than providing advice to the water master, we could just share that memo.
Yeah, I'm not asking for advice. What I'm asking for is something that we can put out in an email to all parties and.
Like a notice of our explanation?
Just so we can build consensus, so our next discussion, if anybody disagrees with that or has a different.
Why don't we circulate the thing that we drafted, and then you guys can decide what you want to do with it.
That'd be okay with everybody? Okay, so if you could get that to Dwayne and Matt presently, we will send it out to everyone saying.
You have it, right? Matt's already got it.
Saying this is an interpretation by who's ever making this interpretation. And asking for comments to it and to weigh in on the next meeting. We'll put it on the next meeting agendas, and then we can come to consensus and go forward. What's that?
Sounds good. And Matt's got it already, so I don't mind if you circulate it.
Okay.
And then I know we're talking about the budget, but I guess this is my opportunity for my monthly harangue about the rules and regs and having a lawyer committee start working on that. This is another one of those topics that we could have fleshed out maybe in the rules and regs. So again, I would encourage the board to consider having some form of attorney committee start working on the rules.
And that, not that specific item, but the rules and regs are on our agenda coming up, so.
Great.
Thanks. Appreciate it.
I got a question.
Go ahead, Jim.
You jogged my brain into thinking about, you know, we're discussing here people pumping their allocation and over pumping their allocation and whether we're gonna assess or not assess. I mean, that's one conversation. But you brought up some people that have no allocation. And it seems like we need to be a little stronger on those people instead of just thinking about sending them a bill for X dollars, because we'll just drill another well and pump and send us a bill, and, you know, it might be cheaper than actually getting water or litigation or whatever. That seems like that will all be turned off. It's just in the judgment, they don't have authorization to pump it.
Or we could be thinking, again, we could be thinking about how to proceed here. But when we're talking about Phelan, for example, we know they've appealed the judgment. They believe they're entitled to take, that's their claim on the appeal, regardless of the court's judgment, which indicates they're not entitled to take. I suspect that if you set a rate and sent a bill, it would not be paid, and it would be necessary. I don't want to assume that necessarily. We might be able to agree to some kind of an escrow account being established where monies can be deposited, and depending upon the outcome of the appeal, could be either refunded or applied towards whatever financial obligation Phelan has, as one example. Another step that might be required, and that goes to another matter or another item on the agenda here, it may become necessary to make an application to the court to enforce someone with no allocation to pay your bills. And that's another reason why I think you need your own legal counsel to present that to the court and get a determination, a court order, which would require Phelan to pay its obligation.
Well, they've been in it since the very beginning. And they knew they were over the line from the very beginning, and they tried to work through it. But are there other people that we know are pumping that have no allocation?
Well,
that aren't fully engaged in the process, the court process?
The Mr. Blumfield's clients, he represented a number of parties, and presented evidence and arguments that his clients were entitled to an allocation as well. The court determined that they were not entitled to any allocation. So all of his clients, in the litigation at least, have no allocation. I don't know the particulars of what their activities have been since the judgment has been entered. My assumption is that they may be continuing to pump, in which case, like Phelan, they'd be in the same category. Thank you.
John, did you have comments?
Yeah, that's Tapia Trust, okay, is one of them. Another thing I'd like to correct.
John, can you just go up so that the microphone can hear you, and just, again, say your name again.
John Ukkestad.
Thanks, John.
Yeah, that's Tapia Trust, it's Tapia, and then it's Ritter Trust in Phelan also. Okay, I'd like to correct Dennis on, Phelan hasn't been in this since get-go. They came in late, so that's part of what they're appealing on. Okay. Another thing I'd like to ask these guys is, what about the people on these, on your fees that haven't pumped their water rights or their ramp down rights? What's the money on that? So some people have paid the $1 an acre foot, but didn't pump what their quantified right is. And that's going to need to be addressed.
Oh, you're right. Good point. Thank you. Gary? Gary Van Dam?
Gary Van Dam, again on the pumpers that haven't filed. I think until we have replacement water in place, it's not fair to them to take their water away when we can't tell them what replacement water is going to cost.
Okay, be careful.
Do you agree with that?
No, that's why I want to know how much it costs.
They've got to dry up their ranches, and right now they're farming today. So let's give them a number. Maybe they can move on.
It sounds like we're going to probably put replacement water on the agenda for our next meeting in the future until we figure it out, and I'm sure Phyllis is going to weigh in at some point on that. So, thank you.
Yeah, again, replacement water might be pretty cheap with all the solar going in. So let's find out what the basin has in it and go from there.
Very good. Thanks, here. Good comment. Warren?
Yeah. Thank you, Warren Mullen, again, for District 40. I have some good news for you. Any party who is in the case, who is subject to the jurisdiction of the court, who produces water, is subject to the administrative assessment. I don't think we need a court order. They're required by the judgment to do that. I think the water master is empowered to assess them with the administrative assessment. If a party fails to comply with the judgment, then there could be a discussion about what remedies would be available and what would be appropriate for the water master to do. And that I would imagine that would include going to the court and pointing out that a party is acting in contempt of the judgment. But I don't think there's any doubt, as I read 9.1, as Keith stated earlier, the intent is for all pumping by any party to be subject to the administrative assessment, and that's irrespective of whether they were a party to the settlement that we were all party to. So the parties who are appealing the judgment, they can appeal it all they want, but they're still subject to this assessment.
And those that aren't even in the judgment are subject to the assessment?
Parties who didn't stipulate to it, whether you stipulate it or not, you're subject to the assessment. So if you were a party in the case, whether you settled or not, you are subject to the judgment. It is a final judgment. It was entered by the court. The court has jurisdiction over Phelan, over Mr. Tapia, anyone who's filed an appeal, they're still subject to the jurisdiction. The judgment has not been stayed by any court, so it's in effect. So I think that's good news for the board.
Thanks. Appreciate it. So, Dwayne, you've heard the discussion, recommendations from staff, how to proceed?
Well, with regards to the administrative assessment, we'll go ahead and proceed based on the 9.1 provision and move forward with that. We'll get the actual numbers from Phyllis, and we'll be able to put that together. So I think that pretty much covers the revenue side of the discussion, and it'll be fairly close to what you see in the budget that you see before you, as far as the amounts. We may have the revised one based on the advisory committee recommendation. So we'll move forward with that. We'll maintain the $1 per acre foot for the 2016 variable assessment, so that each year's assessment's always the same, whether it's a variable portion or a fixed portion. And we'll revise that and bring it back to you with the next meeting with the actual numbers.
And then by then we will have a better, or a final interpretation as to the other issue.
In the interim, what are we doing with the tapias and the rivers? How are we dealing with that? Won't get billed also.
Yeah, they'll get billed in some fashion to the extent that we can estimate what their pumping is. I'm sure Phyllis will make a request, but assuming that they don't respond, we'll have to come up with an estimate if they won't.
Okay, so any action need to be, we can't take action at this point?
Correct.
We will.
Yeah, the intent behind this item was to have this type of discussion to where we clarify these outstanding issues.
Okay, thank you. We're just trying to hurry you up.
I know you are. Well, this is a little easier, I think, discussion to have. What we've put in the proposed expenses for 2017 would be your administrative expenses, and we'll be able to revise those appropriately. We have our fixed items that the board has previously approved, the GLOW-Trans document, the Watermaster engineer. We've made a reduction in the USGS contract water level monitoring as previously directed, and we also included a 10% stabilization fund as recommended by the advisory committee for those items. And if that is agreeable to the board, then we would be able to have an expense side to the Watermaster budget, and with the revisions as noted earlier on the revenue side, we'd be able to come back next meeting with an actual assessment based on those recommendations in that policy.
Okay. Discussion? Now can I move on to item C?
Yes, you may.
Now we're on 7C, consideration of possible action on legal services to answer legal questions from Mr. DeFranco. That's probably a more in-depth conversation than just Mr. DeFranco. But
Yes, it is. The board received a letter from Mr. DeFranco, and he had several questions that were a little difficult to answer, needed some legal interpretation in order to be able to do that. To be able to answer those questions that were contained in the letter. We're getting more and more of these as people realize that, hey, I don't have a water right, I'm selling my property, so forth and so on. And to be able to answer those questions in an accurate and reliable manner, I felt that we needed to get some legal assistance to do that. Since we do not have an attorney, I need to get an authorization to pay one of the attorneys that are familiar with the case or if they want to volunteer, that's okay too. But to be able to help us develop a letter that would answer those questions. And I didn't want to do anything without board's approval and direction to do that in that fashion. So that's where we're at.
thank you. Discussion?
It had to do with, I read it such a long time ago, but it had to do with the fact they were asking why weren't they on Exhibit 4, where should they be, what can they do to do certain things, and so forth and so on. And so we need to have those kind of corrections.
Can you shed some light on that? I mean, do we really?
Because I'm an attorney, but I've been around attorneys enough to know that they can advise the board and all kind of stuff. And
Do we need an attorney to answer those questions, or can we rely on the judgment and our interpretation of the judgment? No.
So I'll just, I'm sorry I have not yet reviewed Mr. DeFranco's questions. Nonetheless, I have no less than 4 additional details that I would feel more comfortable with if either the board weighed in on or we had some additional assistance on. You know, there are just things that come up. For example, a replacement well. I can certainly read the English in the judgment and tell you whether or not that well is truly a replacement well, and that should be a relatively straightforward decision. But it just so happened that there was a complaint pending against that one person. And so, you know, I just felt a little uncomfortable saying, sure, go for the replacement well when there's a legal action out there that I am unaware. Every one of the questions that we have gotten so far, except for some more straightforward things, which is transfer of water rights, has had some little nuance or detail that make us feel a little bit uncomfortable taking responsibility for this. I think we'll feel more comfortable going forward, but to be sort of hit with these 5 early questions without any input from the board or legal counsel felt uncomfortable for us.
Thank you, Phyllis. Keith?
relatively new. There are certain legal issues that it would be appropriate for the board to offer public opinions regarding, for example, sort of discussing the judgment and the language of the judgment, explain to people what it means. That's sort of like a public outreach function that a public entity would have normally. But there's also questions that it's not appropriate for the board to be spending board money on addressing. For example, it sounds like, I haven't seen this Mr. DeFranco letter, but if he's asking questions about what his legal status is in light of the fact that he's not part of the judgment or what have you, and what the status of his property is, that's his own private legal business that we should not be spending public money to answer. And in fact, any of the attorneys here would feel that that might be a potential conflict for them to come in and give advice on that. So, you know, the proper answer, I think, to some of that is go hire an attorney.
Agreed, but it'd be nice for us to be able to get that conversation and be able to talk to somebody to get that answer, so we can say, you need to go hire another attorney, you know, that's all. Just need some assistance.
Yeah.
Here, let me throw this out. My feeling is, and has been, and I've stated this before, this board needs an attorney. Needs an independent attorney that we can rely on, that we can direct these type of issues to. I mean, we have some of the finest legal help out in our audience right now, and who knows this judgment incredibly well. And we get advice from them, which is great. But what I'm seeing at going forward is there's going to be times when our administrative staff or our water master engineer is going to need an independent advice from an attorney and not calling one of the many that have been assisting us so far. The other thing is we don't even have budgeted funds for an attorney. So I think we have to tackle that question and figure it out. If we go forward without an attorney, we're putting ourselves in harm's way. It is going to cost us some money, but in looking out at the audience, our public agencies right now are spending a lot of money on attorneys to attend these meetings, to call into these meetings. And if we just can form a consensus how we would hire an independent attorney that we would bring in, maybe eventually some of the public agencies would feel confident that they don't have to send their own attorneys each time to these meetings, which at the end of the day would save a lot of money for the taxpayers who are in the audience of it, and the landowners and everybody who has to contribute to run the sport. So that's my feeling, that's kind of the discussion I'd like to have, and Adam, I'd like to...
I think you're right. I think, you know, we're going to be faced with questions that we need legal advice on. The only concern that I have is we need to, and it may not be static, but it could change as we go. We need to define what we need this attorney to do, if possible, upfront, because it can be very costly if we did. And we could end up in some conflicts with the attorneys that you referred to. I just rather, that's my biggest fear. And maybe that fear is not going to materialize, but that's why I'm always hesitant when it comes to attorney. But if we could say, okay, we need an attorney to advise us on a question that comes up from pumpers or related to the interpretation of the judgment on, you know, the Brown Act. Just generally like what we do with the administrative responsibility. And then approach it that way, try to find a consultant to help us find the right attorney for that. I'll be for that. I think it's a good idea.
John?
Well, I agree, because it's time and money.
Kathy?
Okay.
Yeah, I think it's really nice that they need to start this year. And I agree with what Adam said, to, as best we can, form what duties and responsibilities the attorneys would have. Phyllis, is that something you would weigh in on too?
Yes, thank you, we would like to do that.
Okay, so I think moving forward for our next agenda, let's start working on for our next agenda, there can be a staff report on duties and responsibilities. Also an estimated budget, since we haven't done our budget for 2017 yet. And I think among the five of us, we can come up with recommendations as to the process of choosing someone. Would that be okay? Okay, good discussion. Any discussion from the public? Lawrence, please.
Thank you, Warren Lone on behalf of District 40. First, I just want to echo what Keith said earlier. And I want to add the point that the Water Master is acting on behalf of the court. So in looking at what function a lawyer would serve and how to handle requests for legal advice, one possible way for the Water Master Board to look at it is, put yourself in the shoes of a judge. And it's generally inappropriate for a judge to give legal advice to a party. And Rob, I'm sure you've been in court and, people come in and want, court do the job for them or what have you, and you know what judges say to that, they usually respectfully decline, which is appropriate because the role is to be a judge and not an advocate. And I think that this, from the standpoint of a lawyer, this issue is challenging because in your function as water master, special master of the court, it's not appropriate for you to give legal advice to private parties. It is appropriate for them to seek their own legal counsel with respect to their own rights. But as Keith was referring to, you do, I believe there's a public outreach function, and part of the water master's job is to provide information to the public, which facilitates the process of administering and enforcing the judgment. So I think there's going to be a gray zone in there where it's not clear. Is someone trying to get free legal advice, or are they asking a legitimate question that you should answer? And it might be difficult to find a one-size-fits-all rule for those types of situations. But lastly, with respect to getting legal counsel for the Water Master Board, I do think it's a good idea. It's something that's done with respect to other water masters. And I agree 100% with what Adam articulated, and I think the consensus is that there needs to be a very clearly defined scope. And the way that this board works, there has to be a unanimous decision for the water master to move forward. So the way I'm envisioning this working is that there'll be a water master attorney who could deal with Brown Act type of questions, procedural type of things. But if there's a dispute among water master board members as to a substantive issue, I think ultimately it's going to go to Judge Komar, or whoever the judge is at the time. I don't know that it would be appropriate for the water master lawyer to be involved in that. I think it's going to involve a discussion with the lawyers for the parties, and then it would go before the judge. And I'm very pleased that so far we really haven't been in that situation, and other counsel have been really good to work with. And we've disagreed on a few things, and we talk about it and land on the same page. So my very last point is that I support Keith Lemieux's suggestion that for the time being, until there's a water master lawyer, I think it would be a good idea to have a subcommittee. So it just adds a little bit more formality to what has been happening informally, and that is the lawyers talking, trying to assist the water master board so everyone lands on the same page with respect to a particular legal issue. And my office is happy to assist in that effort. Yeah, thank you.
Thank you.
Okay, so we did look at this water master and administrator duties, and in the fact that we are going to, at whatever time we discuss it for next year, that one of the things that was important is that they're gonna be the first point of public contact. So it's always good to have like a public information officer. So that would be someone that we could make sure that we, when we're getting, you know, a water master administrator, that we have someone that's strong in being able to coordinate the public input with the attorney and our water master engineer, so that it's transparent and everyone knows publicly that there is someone that they can contact. And then they'll kind of like see, does it need to go directly to the attorney or to the engineer, or if it's something they can ask. So, I mean, who made up this?
Not me, I don't know. Dwayne?
Oh, okay, because I mean, that's just something I'm thinking that we're talking, that when we're looking forward to what we're gonna do later with the administrator as well as hiring the attorney, because the attorney is not gonna be the one you want to have the first public contact.
Yeah, I agree with that. Any further discussion?
Yeah, just to echo what she's saying, I think it is so right on the dot that we need to have some sort of a process for the stakeholders to follow to get to whoever they need. I get a little bit concerned about fellows being bombarded by, 50, 60 questions a month on issues that possibly she doesn't even have to deal with. Right now, we don't have an administrator. I don't know what would be the right approach. I don't want Dwayne to get bombarded with all these kind of questions. So, but I think it would be wise for us to define. I know that would be in the rules and regulations. Everything is going to be in the rules and regulations. But unfortunately, until we have rules and regulations, things are not going to stay static. We're going to move forward. So this is something that we could at least define and later on include it in the rules and regulations and say, look, if you have a question to the Water Master Board, write a letter to the Water Master Board, to the chairman of the board. And then you can always give it to the staff, and the staff can decide what to do with it. Maybe that's one way too.
Thanks, Adam. Can you hand me the?
Yeah.
Just so the public knows what we're talking about. This is a list of Water Master Administrator duties. It's written by Dwayne.
Did you guys see it?
I provided it for the advisory committee.
Okay, so this we've already started with, and you've heard the discussion. So that's how this came about.
And I don't know if that's one of the main things for the administrative committee trainer, is that maybe you just assign someone that they know that they have one person as a direct contact that could put their questions or anything. I mean, I don't know exactly all their reasonings behind that.
I think this is actually a great segue into our next subject.
Okay.
Keith?
Can I speak on the attorney?
Please.
Now, I haven't, this is a thought I just had, keep on mute. This is a thought I just had. I haven't vetted this even with my own clients, let alone with the rest of the group. I just want to throw it out maybe for some thought and discussion about what to do with the attorney. As some of you might be aware right now, there was legislation passed a couple of years ago called SIGMA, and it's forcing people to form GSAs, groundwater sustainability agencies. And those entities are very similar to water masters. They're actually kind of like statutory water masters, essentially. So our firm's been involved in forming a bunch of these, and the stuff that you guys do here in this boardroom has been very instructive because, like here, we're trying to put together new entities. So a lot of the same discussions you see kind of get repeated from location to location. The GSAs that I've been working for have been joint powers authorities, meaning you have a bunch of public entities coming together, typically, and water providers. Each of this is, and you end up with the same two issues that you've got, which is there's no money yet. There'll be money eventually, but there's currently no money to pay attorneys, number one. Number two, every party to the room has their own attorney already, and is looking at everything, so there's some squeamishness about adding yet another attorney into the mix on top of all the attorneys that are already there. So the solution that I've seen implemented, at least 2 of these, I thought I'd mention at least for your consideration, because I think it might be at least palatable as an interim solution. What they're doing, what they've done in those cases is you've got a rotating chair, so the chair rotates annually. I don't recall if we have our chair officially rotating or not, but that's what they're doing there. And then the idea is whoever is the chair, their attorney is the attorney, meaning there's the one person who's going to be providing and talking providing advice during the duration of the chair, and it's provided as an in-kind service. The other, it's understood that that person who's sort of the spokesperson then talks to all the other attorneys. So that person will have the benefit of the other attorneys who are still present, but that way at least you know there's one person, which is the chair's sort of counsel, is the counsel for purposes of the entity during that year while that person is chair, which I think would address Phyllis's question of she would know that, you know, I've got a contact, in this case it would be Lee or Bill, and whatever Lee and Bill, or Bill told her, that would be the answer, but Lee and Bill, it would be understood that they would talk to me and Warren and a counsel for the landowners as well. So that's a thought on how to do it, and it seems to be working out so far.
Great, thank you. And we're trying to put a member in between each attorney, so
Attorney, engineer, attorney.
Dennis Lamro with the advisory committee. I was going to save this until the report, but it seems pertinent right now. At the last board meeting, the board requested the advisory committee look at the legal job description and come back with what it thought. We did that last Wednesday, and is in my memo, the committee feels strongly that the board should hire its own legal counsel. And as far as the job description that AVEK's attorney had put together, agreed with that. Under the 5th bullet, there's a number of items that say assist in billing, those kind of things. We wanted to clarify that the attorney's role in that wasn't to do that, but only to provide overview and look at them from a legal point of view from the judgment. So that's the advisory committee's input on legal counsel as soon as possible. And also clarify in the draft budget, there's $50,000 allocated for legal services.
Great, thank you. Good input. Stan?
Stan Pellissey, Los Angeles, and try and be brief here. I think there's a lot of good input. I also believe that you need your own attorney, and it'll take some time. The sooner the better. I've not thought deeply about an analogous body of attorneys like the advisory committee, but my initial thoughts are a little uncomfortable. I think it's a little different. The advisory committee is made up of a broad spectrum of folks with interests like your interests. The legal advisory team or committee would be a set of specialists in a narrow area that then would be talking to you. Rob, I believe you're an attorney, I'm not sure if anyone else is, which feels very different to me. We may give, as attorneys, advice that might not be the easiest for you to do. I'm also concerned about setting up any formal institutions that aren't in the judgment, because a lot of work went in the judgment figuring out what are the interests, how do we balance them out. And so if you do decide to go with a legal advisory committee, any direction you have about how to balance those interests and make sure it's properly represented would be helpful. And then last comment, I do think when you select an attorney for the board, I think there's a very important role for the attorneys, for the parties. But I think it's a better structure if you have your attorney, that attorney can lay out some general issues, can say, well, let's put this out and let the other party attorneys comment, see if they have some different ideas, but then it comes back to you, ultimately, from your attorney, who's responsible to you and is advising you, and I think that might ultimately give you the best product and the best way to use the attorneys in the room for the parties.
Thank you, Stan. We need to state name and
Lee McElhenney, Antelope Valley's Kern Water Agency. I have expressed my views on this issue a number of times. I continue to believe that you need an attorney whose sense and duty of loyalty is only to the Water Master Board and not to anyone else. Each member of the board, of course, has been appointed or elected by a particular group or entity. And I think Mr. Atkinson expressed an important point a meeting or two ago, and that is once you became a member of the board, you're not just representing that particular group or entity that elected or appointed you, but rather you're representing the entire adjudicated basin. I think that having your own attorney might also assist in bringing the board members together and to be able to be more focused in that regard. Rather than one attorney or a number of attorneys giving input to the individual board members and so forth, based upon the duty of loyalty that those attorneys have to a particular interest, it would be very productive to have an attorney whose only interest is that of the Water Master Board and not any other specific interest. So that's my opinion on the matter. Thank you.
Thank you. I want to throw out an idea and get your views on it. And it comes from Adam and it comes from something Keith has said that kind of spurred his. At some point, we're going to have to figure out a process to find an attorney that all five of us can agree on. We worked through the process of the Water Master Engineer, which was very successful, I thought. It seems to me the only thing I would like to try to avoid, we have a $50,000 budget right now for an attorney. Maybe we may need more, we may need less, I don't know. But I would like to try to figure out a process where we're not spending $30,000 or $40,000 on a search for an attorney. To find, yeah. So, and I've watched the attorneys through the adjudication working together and emails together, and you know, in this room we have attorneys that have worked on this adjudication for years and years and years, know more about it than anyone else. With Lee's comment, I'm a little, I think we need an attorney that actually has been involved in the adjudication process, and somebody that all five of us can find consensus and join. And I don't know if we can find that person or not, because there would have to be a conflict waiver, meaning they would have represented some agency. But the idea I have, at least coming from the committee of attorneys, is would it be possible for each one of us to either appoint your own attorney or another attorney in a committee to come back to us and recommend an attorney for the board? So if they can build consensus on attorneys that they've worked with closely, that they know, that they feel would do this, it might save us a whole lot of money, and it might be a way to build consensus before we even get here. And maybe follow the same process that we did for Water Master Engineer, is form this committee. And as an example, I would think our board would appoint Lee or Bill to be our representative. I don't know who you appoint, Warren or whoever you. So we bring them together, let them work on a consensus based upon everything they know about the adjudication, all the attorneys they've worked with, and bring one or two or three recommendations to us. And that way we can save on the search. We're all represented equally on that committee, and they know more of what, who would have the best skills to be an attorney for us than I think any of us do at this time. Thoughts about that?
I think it will save time. and money. The idea, I think it's a good one, except somehow we have to have at least broad leading in the board, broad parameters on who could say, because I was with these attorneys for a long
I
time.
mean, you know who the,
And I saw the emotions in some of them, and there are some that did very little or represented very small water agencies, and then they were a lot more balanced and easier to. So if you ask me, I can give you 5 that I think could work. But obviously, I'm not going to do that, and I'm sure I would appear to be biased. But my point is, if in the interest of saving time and money, at least for this initial go around, if we could say, okay, yeah, we'll do that. We'll have these attorneys come up with 4 or 5 names. But we at least need to say, well, this individual could not have been a main player in this process. In other words, we don't want somebody who was representing a much larger number that devoted a lot of time and emotions into the process. Because I don't know if they can be divorced from their clients and their feelings and what went down. But if we could say, okay, somebody that represented someone with a small amount of water rights, or 20 pumpers as opposed to 1 pumper, or those are the parameters that at least we need to think of, and maybe provide this group of attorneys to come up with a list of attorneys that they can recommend to us for interview. My preference, the best way to deal with this is to bring somebody brand new that knows nothing about these cases, like what we did with the engineer.
and that might be the recommendation they come with, I don't know, but it just seems that would be a way to kick off this process. And we're giving the duty to people we trust and we look to. And maybe they come back with us with 3 names of people who have never been involved in the adjudication. Or within the adjudication, there were 2 or 3 real good consensus builders that fit the qualification we used to say. When it be someone, the landowners would look at it and say, no, I'll never want them because they represented, a public water supplier and vice versa.
Right.
But it's at least a way to kick off this process quickly, something that we put somebody on the committee we all trust to give us the best advice as to who would be best counsel for here.
Just to be clear, if we get someone that was not involved in this case at all, what would be the downfall of that?
I just don't know if that's the qualification you have to put on. Maybe our committee, if you agree with the committee process of doing that, maybe that's what they will decide. I think, I'm not sure I'm going to leave it open. I would like to hear, the names they bring forward, but I know, within the adjudication, a whole lot of time, energy, money was spent getting those attorneys up to speed on the adjudication. Maybe we do need somebody with conflict. I don't know, but I'd like to hear a recommendation from them. And all I'm trying to do is avoid us having to go out and do a search in a 9-month thing. I would like to kickstart this process.
Sure.
And maybe if everybody would agree with Phyllis on that committee too, she would probably have some pretty good input.
Do you want to put Phyllis through that?
You got legal to do too.
I'm open to the idea. I just think maybe what we just put a time limit to it.
Yeah,
I don't want this process.
I'm hoping we have a recommendation by our next meeting, if we agree to do this. So,
I want each one of the board members to recommend to have their legal representation. It's your legal representation. Recommend.
you may want me as your person.
Well, I kind of agree with that. They got to be kind of neutral. We all have names that there's no way in hell that guy's going to be right or this, that. But I mean, there's some that seem to be pretty cohesive and trying to get to a solution, and, you know, I think there's some flexibility there, but, yeah, we could do that for the next meeting, I think.
Keith, what's your thoughts?
Keith Benitez, I need to talk to Leo, but I'd be willing to be on that committee if so instructed.
Got it.
I'd like some input from our legal group out there. Is this a viable option, or are we spinning our wheels?
Just reporting. Oh, Rob, I think it's a good idea. I think it's an interesting idea. And, you know, I think to a great extent, it depends on who the lawyer is. And I wonder, there may be some lawyers in the case who, like Adam was saying, weren't as active, but they were experienced water lawyers. They just, for whatever reason, in this case, ended up with a small player. And there might be some people that we could agree on, but, you know, I agree with what Dennis said, that we do need someone who's neutral, and, you know, for an attorney who was in the case, as you and I both know, there may be some, you know, conflict issues and waiver type of issues that would have to be addressed. They're not insurmountable.
Oh, well, Warren.
Yeah, I know. We always see eye to eye, exactly, on these issues. You know, so you know, but I like the notion of saving money, and I could see, bumped into a few legal recruiters in my career, and, you know, it's not the cheapest adventure. So, long story short, I'm on board with the idea. I think it's a good one.
Great, thank you. John? Can you
Yes,
come?
John, you can step.
Yeah, just come on up, please.
I have a question
Don't trip over the
for-
board.
Jim Brockman had very little involvement in this adjudication. At the beginning of the adjudication, he's an excellent attorney. He also, I don't know if he's still with the law firm that represents the city of Palmdale.
Jim Markman? Oh, Jim Markman?
Markman, yes.
Markman's a good attorney.
Yeah,
He's a very good attorney.
Extremely knowledgeable.
And very knowledgeable. Okay, so I'd like to just throw that name out there.
Sure. Thanks, John.
Thank you.
Appreciate it.
Or-
Ron?
Oh, sorry,
sorry.
just one point of
Let Kathy
clarification.
go first.
So it's just gonna be 5, so like for us, like since I'm the alternate, it would be Leo's pick, so you're only choosing 5?
Well, I think what it would be, I don't want to say how you guys would do it, I don't know if it would be
Right.
Leo's pick or the public water supplier's pick, because of who Leo represents.
It's
I mean,
whoever we choose.
I'm
in
going
other
back to
words.
AVEK to get direction who we would choose.
Right.
I have
And
a
like
pretty good
them,
idea, but.
Yeah, like it's to them, it doesn't necessarily have to be attorney, just a person that you feel could be in there with the best, yeah, yes.
Kathy?
I was thinking the landowners might want to choose 2 attorneys, but I would think we presumptuous.
Well, that's not, just point of clarification, it's just.
Ron Smith.
Ron Smith, yes, I agree with you, Rob. I think that's a good idea. The idea of having somebody come in with no experience whatsoever, you're not only, you have to pay them to get up to snuff, right? And then they weren't in the room making the deal, so they don't know what the spirit is. Sometimes, as we found, there's little gray areas here and there. But the attorneys that were involved know what the intent was. And so I think it's good, and like I agree with you guys over here too, that there are attorneys that were not as controversial, and they didn't have as many horses in the game, and they can be, you know, even though they took care of their clients and they might still have a client might file a conflict waiver. The conflict waiver would be for something that's not that big of a deal, and I think they would be neutral. And then the bottom line, like we've discussed before, if they make a decision and give you guys a decision that this is the legal answer, and there's attorneys out there that disagree, well, the judge is going to decide anyway, right?
Well, 5 of us can't decide, the judge will decide anyway, so we're doing a great job deciding and building consensus. So, it seems that the consensus to move forward on this, I don't want to put any rules on it, I would just, and maybe this would need a motion that we form a legal committee, or not even, we form a committee
where each one of us would choose
An ad hoc.
whoever we wanted to choose and bring them together as soon as possible.
So under the Brown Act, if you form a formal committee, then it becomes a Brown Act committee. If you, it could be an ad hoc committee.
Okay.
In which case, you don't take formal action, you just give us the head nod.
Consensus and
And
See, I listen.
yeah.
so, I'm not sure what your intention is. I think it would probably be easier for the lawyers
Got
to
an ad
talk
hoc.
candidly if it was not a public meeting
Okay.
about certain attorneys.
Got it. So procedurally, we got lots of terms and rooms. Procedurally, if we don't take any action at all, just a consensus to do this and have our attorneys and whoever we choose get together and bring us back a recommendation to the advisory committee. I think.
I'm seeing Lee gave me the head nod, so I think we can do that. We just
Lee, you
need to
think
find out who
that's-
the landowner folks are.
Consensus is still an action. A full consensus of the board is still an action. So you can take the action, as Keith was saying, you just can't form a standing committee that would be under the Brown Act. You can take consensus and an action forming an ad hoc committee, which is not under the Brown Act. And set a date and
I don't know,
sunset.
I'm not sure that's clear.
This is really mostly for your information. I'd like to provide a status report of where we are on the 2016 annual report and the beginning of the rules and regulations. Recognizing that the 2016 annual report is due to the court August 1, so we really need cooperation and buy-in on where we're headed, and so I wanted to provide you with a bit of a status on that. You have seen several slides regarding oh, yeah, actually, it's that lighting and she actually taught me how to do it, but I forgot to do it.
There you go.
Okay. You've actually seen several slides that we provided in the past for draft table of contents, but essentially we have sort of cleaned that up a bit. And the body of the 2016 annual report really will provide a description of the Watermaster activities, the forming of your board, and we have a lot of details of that both in the judgment as well as when you filed to the court to delay the filing of the first annual report. There was a lot of details and information in that. So we're going to put the draft sections 1 and 2 together, and obviously we'll want the board input and revisions on that. Section 3 is essentially the technical section of the report where we're required to talk about the current safe yield calculation that's in the judgment, and we're required by the judgment to provide safe yield component monitoring. And I'm going to talk a little bit more about what that involves. The meat of the report, however, all of the data are going to be included in the appendices. These are not necessarily in order, but it provides a list for you that we're planning to put in the appendix of the first annual report. Some of this will not have any information in it. We will just simply have it in there as a placeholder and say, for example, there is no carryover water in the first year, for example. And so this just is where most of the real details are going to be in the appendix. And then I included the rules and regulations as a bullet at the end of that list. We won't have the rules and regulations complete by the time that we file the 2016 annual report, but we do hope that there will be some approval of our draft recommendations for metering, and I'm also going to talk a little bit more about metering in the presentation. There are some outstanding data needs. We're working with the administrative staff to fulfill these. Several financial details are there. We're still finalizing, as we discussed today, the 2017 annual report, but we also need the fiscal report for 2016. I think that's in place. We just need probably, I think, to just subtract the $333 that we had for December 2015 just to keep the calendar year clean. And then a financial audit is required, and we'd like to obtain that and include it in the annual report. The updates to the production database, I'd like to mention that we really had out notices to these parties that we do not have their production reported and that we need it. And regarding to notice, there's a requirement in the judgment for a notice list. And so what we have are essentially a lot of notice lists that have been compiled over time from people attending, but we really need to get a more formal notice list together for the parties of the judgment. One of the things that we're going to be needing to do is to notify everyone associated with the judgment that a draft annual report is available for their review prior to your having a public hearing on that. So we're going to be working again with administrative staff to get that notice list firmed up. So a couple of things about the technical portions of the annual report with respect to monitoring safe yield components. Most of these components are just the typical surface water and groundwater data sets that we're very used to compiling. We're in the process of getting all of this together: precipitation, stream flow, water levels, production, return flows, imported water, etc. There's a requirement in the judgment that all relevant data need to be included in the annual report. So these will be summarized in the text of the body of the report with data in the appendices. And then with respect to the groundwater conditions, we'll be preparing 2 groundwater contour maps. One for March 2016, one for March 2017, and then doing an electronic subtraction of those maps to come up with a change of groundwater in storage for calendar year 2016. And we are going to be using all of the water level data that everyone has been helping us put together. I'd like to thank everyone involved in helping us to assemble this. We have water levels and/or well records right now for more than 300 wells in the valley. 200 plus of those, of course, were from the USGS ongoing CASGEM monitoring program, and they're also their National Water Information System that they keep, the NWIS system that they keep water levels in. But we also received a significant amount of information from many parties in the judgment as listed here. Los Angeles County Department of Public Works providing information on 56 wells, Palmdale Water District another 24. And I'd like to also recognize and thank John Ukkestad for encouraging the mutuals. We have a lot of information now from the mutual water companies, and they've been very responsive and helpful to me in providing details on their wells. Now, not all of these wells that you see listed here, 200 plus from USGS and then another 107 that we've compiled from others, not all of those have 2016-2017 water level records. But having these beginning to be compiled as producing wells within the basin, I think will help us all going forward. For the wells that we do have water level records, and there's more than 200, I have 193 plus, but I'm continuing to get more information and data. So we now have more than 200 wells that have both March 2016 and March 2017 data. So we're going to be constructing, again, water level contour maps for those 2 time periods. The reason that we've selected March is because that really is the time period that we have most of the data, an overwhelming amount of data really compared to the other months. It is the beginning of the irrigation season, but I think that they will produce good water level data. That's what it looks like so far in our preliminary mapping of the information. And then again, looking at those 2 surfaces and producing the water level change over all areas of the adjudicated area, and then using aquifer properties to help us estimate a change in groundwater and storage for that calendar year. I also wanted to introduce this. I just have one slide on it. This really is the idea of using something as a future tool. There's no decision to be made. I just simply would like to begin the discussion that we really are going to need additional tools for characterization going forward. The USGS has constructed a basin characterization model. And I want to start by saying this is not the groundwater flow model. This is not that model at all. This is simply a more watershed model. And it helps us with some of the specific yield components required by the judgment. For example, infiltration of precipitation and infiltration of stream flow. We could easily obtain this from USGS. Would like to evaluate it, obviously, before we use it as a potential tool. and apply it to stream flow infiltration as a specific yield component going forward, potentially. It's a publicly available package. It's a module that goes on top of their current groundwater model. And again, we're not suggesting that this be used for the 2016 annual report. We need time to evaluate it. But I do think that we would like to see some kind of an electronic tool, numerical model tool, to use for future applications. We recognize that this needs to be a very transparent and open process. I did introduce this concept with the advisory committee, and that's really all I wanted to say about it today, that we just would like to consider this going forward. I want to jump to the rules and regulations. One of the things that is required by the judgment is that meters are installed on all parties' pumping wells, except for the small pumpers, by the end of this year. So we're running out of time here. I know that people really need this guidance to be put in place sooner rather than later so that they can begin to plan for installation of meters on the wells. Therefore, we are focusing our efforts for the rules and regulations on this particular aspect. And I hope that we will come back to you at the end of this month with some guidance that everyone feels comfortable with, that we can approve at least as draft, and include that also in the 2016 annual report. Just for concept purposes, I included two photographs. We want to move from open pipe flow and irrigation in channels to a more rigorously metered situation. So that's the goal for the meter installation. Obviously, our guidance will include the requirement for appropriate industry standards. For example, AWWA and others have good guidance for meter installation, as does the factory installation records. And we're also looking at other meter requirements from other adjudicated basins. Mojave has some good details for meter installation guidance. And we also have this from other states. Texas and Kansas also have detailed guidance recommendations, many of which are not appropriate for us, and we recognize that. What we really are trying here is to come up with flexible and certainty. So the flexibility and certainty components of this, I think, are the most important for those getting ready to install meters. They want the flexibility to be able to make it work for their system, but there needs to be some certainty so that we actually get accuracy. Accuracy really is our key here. For proper meter installation, we're probably looking at plus or minus 8%. So I feel comfortable that we got good input, by the way, from the advisory committee. We are very grateful for their input because they're the ones that really know the ground truthing of this. Some quick considerations. Obviously, the meter selection needs to include and consider what it's getting ready to be used for. How much does the well pump? How much is it used over time? What sort of accuracy do we need? What kind of error can we anticipate? And then, of course, the longevity associated with the meter that's selected for the appropriate application. There will be an initial calibration that's typically done at the factory. We will get factory sealed meters involved here, but there will be ongoing work as well. Installation, of course, in accordance with specifications. And our idea here is that we would look at pre-qualifying contractors within the valley. For example, many of the mutuals already have certified contractors, or I'm sorry, most of them are certified employees, but they have certification and knowledge on meter installation, and they can document well what has been done and provide that information to us. We also have been working with the technical advisory committee and their technical member, Larry Rotman, who many of you know is a very well established and reputable well driller in the area, who has already installed many of the wells and meters in the valley. And we anticipate working with sort of valley pre-qualified contractors to help us document that meter installation is done according to specifications. There will be a periodic recalibration process that will also be included in the meter installation guidance that we're putting together. And again, we are hoping to have this a draft of this together by the end of the month so that everyone can review it. If we hit some bumps and there are some unworkable components that we need a little bit more time to work through, then I think that the judge would understand that. But we would like, if possible, to include a draft meter installation guidance with the annual report. So here's the ugly truth of the schedule. I have to take a deep breath every time I read this first one. Our administrative draft needs to be due to you at least by June 27th. I'm assuming that you will have a regular board meeting the 28th, which is a Wednesday. This only gives you one day before the board meeting, but it will at least, and then obviously we would attend that board meeting and walk you through the annual report so that we can figure out if there are holes and other things that we need to work on including. It would help us if we could actually get substantial comments on the content back from you by July 11th. I know that's a very quick turnaround, but I'm not asking you to go through every page of the annual report in every detail and QC numbers and provide wordsmithing. We only need to really understand what is not in the annual report that needs to be in there and decide who's going to do it and how best to get input from you. So that would be the first opportunity for comments on the administrative draft report. We will quickly turn around a draft report from that administrative draft, providing it to you at least by July 17th, and then you would have the opportunity to see a more finished product, as it were. And maybe comments could come back on that more finished draft by the 21st. These are all just my looking at a calendar and trying to work backwards. I'm certainly open to working with you in whatever way that you would like to see the schedule modified. But you do need to have a final annual report in your hands on July 26th, the day before your, what I assume will be your July board meeting. And the reason that you need that is because you actually need to adopt it, and we need to have a public hearing. There's something else that has to happen that I don't have here. Oh, I do have it, I'm sorry, it's in the third bullet there, draft report. We need to provide a notice to the parties in the judgment that the draft report is available, perhaps on a website, that everyone can download and review. That's required in the judgment, that we allow public review of the draft report. And then at the public hearing, which I'm assuming would be on July 27th, but we can pick another date as you wish, you would have a public hearing and formally adopt that report. It is due to the court August 1st. That's a Monday, 2017. And if there are comments that we need to clean up, we're only asking for the difference between July 27th and that weekend to do it. So I'm hoping that, I know this is incredibly aggressive to ask you for this level of review, but essentially, you know, even though we asked for a 90-day extension for filing of this annual report, it took us 30 days to get a contract and get everything finalized, and so we're really on this very aggressive schedule. So we ask for your cooperation and appreciate it in advance. That's really all I have. Be glad to think so. It's not in the judgment anyway. If there's something else related to the bond, I'm not sure.
Is there any brown
Well, it presumably would go out with the agenda 72 hours ahead of time. If it's circulated to the board members before that, then it needs to be available to the public at the same time it's circulated.
So our regular meeting is July 26th, and you want a special meeting on the 27th?
Oh, I'm sorry. If your regular meeting is on the 26th, we'll get it to you on the 25th. Did I read the calendar wrong?
Meeting on the 26th, I think. At least it's on my schedule. So our next meeting, since we're going through it.
Last Wednesday of the month.
Yeah, last Wednesday of the month. So our next meeting is scheduled June 28th.
That's correct.
So that's correct on there. And
Yes.
then our July meeting is scheduled for July 26th. So that would be the date that we would do the public hearing.
Thank you, and I just have those last, next to the last two bullets probably wrong, but we will change final annual report to be due to you on July 25th, and adoption in the public hearing on the 26th.
Perfect.
Oh, thank you. Someone just reminded me that you need the annual report 3 days before, so I will work backwards on that. We can still do that, as long as you can get us your final comments July 21st. I think we can make that happen. We might need to move the July 21st back a bit.
So that takes care of AVA. And did you go through B?
I'm sorry? Did I miss something?
No, I think you went through the status update rules and regulations.
Yes, I'm sorry, I don't have anything to update for the rules and regulations other than the meter installation guidance version 3.
And director staff reports, item 9, and if we could have lights. Kind of nice. Perfect, thank you. Update on interim administrative activity, staff report, Wayne or Matt?
Yes, we have we've finally done all the this has to do with the landowner representative alternate election. We have the nominees. We will be preparing a ballot this week to go out to everyone for that particular election. We will be soliciting some, since we don't have the ballot information that was on the previous ballot, because that all went to Colorado with the federal government. We may need to get some assistance with regards to the ballot, the exact wording that's on the ballot. But other than that, we hope to get it out this week and be able to report back at the next meeting of the results of the election. Mike Michelle with the city of Palmdale has left the city, or is in a very short time will be leaving, but we did get Gordon Fair to fill in for him, and so it was a little, that's why it took a little bit of time to get that done, as he was making his plans. So that's all we have to.
What's the nominees?
I don't have them in front of me. There was there 4 or 5. I neglected to bring the names. So Mallory, about 4 or 5 individuals.
Any further questions? Any questions from the public? And then 9A2.
Yes, 9A2, and excuse my term of legal presentation. I don't want to do that, given the recent discussion today. But what I see is a potential problem as we go from where we are today into next year, when the ramp down begins, that there needs to be a good discussion with regards to what your pumping rates are, what the carryover is, how that's all going to work, you know, how the water rates accounting is going to be performed, so that people can begin to make some of their decisions about what they're going to do next year, and have some idea that they know that they overpumped this year, how much do they get? If they buy imported water, what does that really do to their accounting, so that people can have an understanding, and also just to make sure that we're all on the same page, moving in the same direction with regards to that. Because I know it's going to, you know, we've had a difficulty just with the assessment here, was we actually get to the ramp down and our calculations and what replacement, what's replacement costs and not. We're gonna have that pretty well defined, and people are gonna probably need that information sooner rather than later, especially people in the public who are trying to make decisions about how they're going to grow whatever crops they're going to be growing, or serving their customers through retail or industrial customers moving forward. So I think it's important that we kind of address that issue kind of up front so that we have a certain set of rules. Now, I know the rules and regulations are probably going to cover all of that, but I don't know if we can wait that long, at least have a general idea of how that was presented. Not to add anything to Phyllis's agenda, but she may be able to help us with that maybe after the annual report's done, and she can put together a draft, and then we can all kind of take a look at it and go from that point.
And hopefully by then we might have a turnout.
That would be nice.
So any action on that thing?
No, just direction to staff would be sufficient.
And it says there's an advisory committee recommendation. Dennis?
Dennis Lamro with the advisory committee. Our last assignment from the last board meeting was to come back with a list of recommended items for a simple majority of the board to vote on. And this was a quick discussion. The advisory committee appreciates all the cooperation that this requirement of unanimous voting has generated. So the only option, or the only item that they thought we could switch to simple majority is approval of minutes at this point.
Thank you.
Discussion?
I just want to add to what Dwayne says. I think, and I know we have a lot to do, and we only need once a month, but we need to figure out a way to do stakeholder outreach and education. It doesn't have to cost a lot of money, but I think, this is a brand new process, and a lot of people don't understand the judgment. I don't know, I'm open to ideas, maybe the advisory committee can help us with that. It doesn't have to be done by attorneys. We can always use attorneys to make sure that presentation that can be made to the community are good and within the judgment. But even at the engineering staff level, through maybe the integrated regional water management plan, there are a lot of avenues that we could outreach and educate the community on what is this all about and how are these water rights and the ramp down and all that stuff. So I really think that there is a need for that. It needs to be continuous, but in the beginning, at least, if we do a few workshops, presentations, maybe through, like I said, the integrated regional water management plan, possibly even through AVEK board meetings, or the state water project contract. I mean, whatever avenue where we see people attend.
I think that's a really good idea, and I think we need to do that. Might do it parallel with our rules and regulations as we get those ready and start thinking about public meetings to put them out and explanations. Going back to the item that the advisory committee was working on, I think it would be good if we could decide on the functions that our board could work on simple majority. It could be left to the rules and regulations, or we can just talk about it now. It would seem to me that the consent items we have today might be something we could leave for a simple majority, which would include payment of bills, approval of minutes, and finance report. And what that would allow us to do is, if for some reason, and I'm sure somebody will stand up if I'm saying this wrong, if we can decide per the judgment on the items that we can do by simple majority, that's going to change what is going to be necessary for our forum to even conduct an official meeting. And that way, if we had a situation where one of us was unable to attend at the last minute, we could conduct our meeting, pay our bills, go through the consent calendar, and at least conduct that part of the meeting. And then, that's my thoughts. Any objections out there? Does that make sense? So, I think we should discuss it, see if we've worked together for a while now. We seem to be able to come to consensus on things. And are we ready to make this big jump into our rules?
Yeah, my preference is to go through the process of the rules and regulations and try to work that through that process. That way we provide opportunity for the public input. So when we do decide these other things that are going to be unanimous and those other things, that's just simple majority, everybody's on board. That's the key thing to me. I mean, everybody needs to buy into it. Whether it's paying the bills or approving the minutes. The advisory committee thinks the only item we should have with simple majority is approving the minutes. So that kind of telling you that there isn't a desire for anything but unanimous decisions.
Thank you.
Is it a possibility to, if there's only 4 of the 5 here, to have a 4-0? It's still a unanimous vote, but it only requires a 4-0.
My understanding, not according to judgment, everything at this point requires a 5-0 vote. But we do
I was
have.
saying this in lieu of the simple majority.
I think you don't have a form. That's if you only have 4.
Until we decide what business we can conduct as a simple majority, then we're going to have a quorum. Phyllis, on rules and regulations, that's something I imagine you're going to be working on too, is providing input into what things you think the board should be conducting by simple majority.
We certainly can. Yes, I mean, the rules and regulations certainly need to be clear about those types of procedures.
Right.
Within different bodies.
So, just continue with the 5-0 until. Okay. Good consensus.
We agree with that.
Yeah, look at you. Well, if you agree with the advisory committee, can we move ahead on just the approval of the minutes, and then we have something majority for sure of minutes?
It looks like it's getting a little better.
I think that's 60.
60, yeah, that's right. I had one this morning, 59.
So we've received a few more over the last couple of weeks, so we'll update the spreadsheet and send it over to Phil.
Yeah.
Did Water District 40 got you the production data?
Yes, thank you.
And have we even put out a second request yet?
No, we haven't, but we'll do that this week.
So, yeah, let's get a second request out, put it on the agenda, let's have a list of who has it, and then work on a process for getting it done. Is that
Yes.
your issue, Phil?
Yes, it does. I mean, we can get included in the 2016 annual report anything that we get in July. I feel like that. I feel like it's important to the court that we demonstrate that we're reporting the production. So that seems important to me.
Good, thank you. And then another item I'd like on the agenda is start the discussion about the replacement water and cost for it, and start how we're going to be operating that. I think staff will do a presentation next time on recommendations. Then the other item for the agenda is how we're going to handle the assessment for the pumpers that are not on either Exhibit 3 or Exhibit 4, and start looking at that issue.
Although I think either Keith or Warren has said that the judgment allows us to build those.
To assess it, but I think that it's going to be a broader discussion than just assessment. So, and I would imagine our watermaster engineer will talk about that a little bit too, give you all the tough subjects. And those are the items.
The attorneys.
Oh, and then the attorney, if staff can work with each one of us or the group that's going to come back, and hopefully they can have some recommendations in time for the advisory committee, so the advisory committee can weigh in by our next meeting. I know it's pretty quick, June 26th, but if we, even if they all got together on the phone and chose their top 3 or 4 candidates, and then those candidates would have to be contacted to see if they even had an interest, and then vet them through the advisory committee, and if we were far enough ahead, then bring them here to have discussion with during that agenda, as mentioned. Or maybe we need next meeting to figure out the process, and then the July meeting would be where we have a discussion. What's your thoughts?
Fine.
Probably.
Fine. The only concern I have is Mr. DeFranco. How are we gonna give him an entrance clause? Are we gonna go in?
It sounds like we kind of vetted that out. If it's, it sounds like he's going to need his own attorney to take a look at it.
Okay.
And then see where we'll go from there. I think.
Also, do you want everyone to get those watermaster administrative duties as well as like the advisory board and the others that didn't get it, so they can kind of look at, to add, for them to see it, discuss it, things they want to add to it. Yeah.
Is that the administrative or the administrative?
This one is the minute for the administrator duties.
Okay. And where would you like that to go?
So definitely the other board members to have it, as well as the committees, for everyone to have input to it.
Has the advisory committee weighed in on this yet?
That came from them.
Came from the advisory.
I provided for them. I assume they may have changed it around. I don't know.
Okay, so give it to the board members.
Give it to the latest.
Dennis will.
Emails.
Okay.
That's mine, actually.
You want it back?
Yes, I do. I don't mind giving copies of email.
And Adam, anything else on the agenda that you?
I think you got them all. I can't think of anything else.
I have a draft annual report. You want that on the agenda?
Mm-hmm.
So I'll add that. Do you want to do anything with the budget?
Yes,
Yeah, the budget will have to be on this.
Okay, got it. For approval this time.
Approvals
And assessment.
and assessment.
Got it.
Yeah.
Replacement.
Anything else, Adam?
No, we're ready to adjourn. I just want to thank Matt for being the chair for the advisory committee, for public water supply committee, I should say. Kelly, that you got a heck of a good job. Congratulations. Sorry, Dennis.
I'll get you. Kathy, anything else on the agenda?
No.
We're good. John? Kathy? We're good?
Well, Rob, I just want to open it up.
Oh, yeah. And at this time, I would like to open up for any comments on any of the agenda items from those who have been patiently on the phone. Any comments? If you're unmuted now, you can talk. Well, we want to thank you for joining our meeting, and we're going to mute you again in about 30 seconds. Okay, so before we adjourn, I just want to thank the board and all of you out there in the audience. This is how these meetings are supposed to go and how they're supposed to be run, and the input and transparency is really refreshing, and I really appreciate it. Gary, you had a comment before we?
Yeah, I have one comment as a landowner on how long are we gonna have to have?
Gary Van Dam.
Gary Van Dam. Landowners, how long do we have to get our meters in place from now till when?
The end of the year, December 31st, 2017.
Okay.
So the question.
End of the year.
You know, I'll repeat the question and everyone heard the answer, but the question was, when do the landowners, I guess, when does everyone have to have their meters in? Is that Exhibit 3 and Exhibit 4? Yeah. And it is by the end of 2017.
And also, on a sealed meter, what were we, the advisory board brought up that sealed meter. Did we ever get to the bottom of that? How are we going to determine the sealed meter?
I think at this time, there was not a strong indication from the advisory committee attendees that the meter would have a watermaster seal on it. It'll have a factory seal, obviously, and require factory calibration. But it didn't seem to me that there was a lot of need for having a watermaster seal on the meter.
Yeah, one topic came up that the farmer that's bringing, using different wells on leach property, if it's sealed, how do they reseal that meter?
And so you can read it without breaking the seal. And at this point, I think we are thinking that there would be 1 meter per well.
Okay. Any other questions from the public? I think we're ready to adjourn. Is there a motion to adjourn? Motion by Adam to adjourn. Second by John. Any discussion? Seeing no discussion, all in favor of the motion to adjourn the meeting, say aye. Aye. All opposed? Motion carried unanimously.